5 seconds to go. Start. Hence, rejection of the respondent's claim solely on the ground that the family is in receipt of pension and other terminal benefits is in contravention of the decision in Canara Bank Supra, which is binding on the appellant. The appellant's contention of the respondent being ineligible for employment on compassionate grounds on the ground of age bar is untenable. The appellant had not raised an objection to the overage of the respondent in the letters and counter affidavits except in the letter dated 30th October 2002 rejecting the initial application of the respondent dated 15th January 2002. Even otherwise, the issue of overage could not have been raised later, having regard to quashing of the decision contained in the letter dated 30th October 2002 by the order of the High Court dated 16th June 2015, having regard to the doctrine of res judicata. Moreover, the appellant had the power to relax the age, and in the present case, without considering such power of relaxation, the appellant rejected the application on account of receipt of terminal benefits and family pension illegally and in an arbitrary manner. That apart, there is nothing on record to suggest that the appellant made any bona fide assessment of the financial condition of the family of the deceased. It could be inferred from the submissions of the appellant that they reached the conclusion that the financial condition of the family is sound only on the grounds that the family received the family pension and other terminal benefits without, however, appreciating the ratio of the decision in Canara Bank Supra, where receipt of terminal benefits was held to be of no consequence at all. Finally, it was submitted that substantial time has elapsed since the death of the respondent's father, and that the respondent, having been made to unnecessarily wait for long, the present appeal deserves dismissal with cause to the respondent. Precedents on the point of compassionate appointment have been cited before us by both parties. Those, along with other precedents, do need due consideration, and we intend to do that as the discussion would progress. The core issue arising for decision on this appeal is whether the division bench of the High Court was unjustified in not allowing the intra court appeal of the appellant and in upholding the judgment of the single judge while directing the respondent's appointment at a point of time when he was past 44 years of age. There are also certain sub issues which would fall for our attention. We propose to examine the same too at a later stage after noting the salient features of the scheme of 1993 and the multiple judicial precedents governing the field of compassionate appointment. The scheme of 1993 was introduced by the appellant in supersession of all earlier circulars, instructions and guidelines. The objective of the scheme reads as follows. The scheme of employment on compassionate grounds, hereinafter called scheme, has been evolved to help dependents of our employees who die or become totally and permanently disabled while in harness and to overcome the immediate financial difficulties on account of sudden stoppage of the main source of income. The employment under the scheme will be considered only if there are indigent circumstances necessitating employment to one of the dependents and the deceased employee's service record is unblemished. Mere eligibility will not vest a right for claiming employment. The bank reserves the right to reject the application received under this scheme. Other notable features of the scheme of 1993 are Application for employment should be sought within 2.5 years from the date of death of the employee. In case the dependent of deceased employee to be offered appointment is a minor, the bank may keep the offer of appointment open till the minor attains the age of majority, provided a request is made to the bank by the family of the deceased employee, and the same may be considered subject to rules prevailing at the time of consideration. Where no dependent of the deceased employee within the prescribed age limit is available for employment, the bank may, at its discretion, relax the upper age limit up to a maximum limit of 5 years. In case of dependents belonging to SC/ST category, the existing concession for SC/ST for the upper age limit will continue to apply, but in any case it shall not exceed 10 years, that is 5 years for being SC/ST candidate and another 5 years under discretionary powers, provided there are no other dependents available within the prescribed age limit. The procedure for making applications is provided in paragraph 11, requiring applications to be made in the formats furnished in annexures 1 to 3, whereas paragraph 12 enjoined that the offer of employment would be restricted only to one person. The policy to appoint a dependent family member of an employee who has died in harness or has been medically rendered unfit to perform further job, thereby leaving the family in utter penury, is not of too distant an origin. Going by law reports, the policy seems to have originated during the 70s of the last century and gained momentum in the following decades, with this court laying down guidelines from time to time for grant of compassionate appointment. The rationale for such appointment has been explained in Haryana State Electricity Board versus Hakim Singh in the following words. The rule of appointments to public service is that they should be on merits and through open invitation. It is the normal route through which one can get into a public employment. However, as every rule can have exceptions, there are a few exceptions to the said rule also, which have been evolved to meet certain contingencies. As per one such exception, relief is provided to the bereaved family of a deceased employee by accommodating one of his dependents in a vacancy. The object is to give succor to the family which has been suddenly plunged into penury due to the untimely death of its sole breadwinner. This court has observed time and again that the object of providing such ameliorating relief should not be taken as opening an alternative mode of recruitment to public employment. Decisions of this court on the contours of appointment on compassionate ground are legion, and it would be apt for us to consider certain well settled principles which have crystallized through precedents into a rule of law. They are not in sequential but contextual order. Appointment on compassionate ground, which is offered on humanitarian grounds, is an exception to the rule of equality in the matter of public employment. Compassionate appointment cannot be made in the absence of rules or instructions. Haryana State Electricity Board versus Krishna Devi. Compassionate appointment is ordinarily offered in two contingencies carved out as exceptions to the general rule, viz., to meet the sudden crisis occurring in a family either on account of death or of medical invalidation of the breadwinner while in service. V. Shivamurthy versus Union of India. Stop.